Good day, ladies and gentlemen. This is Dr. Frel, your professor. Hello class, good morning. We're back to our course, Law-Related Studies. Our second video is on the Family Code of the Philippines. Under Executive Order number 209, adopted on July 6, 1987. What is Executive Order number 209? It is known as the Family Code of the Philippines, which was enacted into law by President Corazon Z. Aquino on July 6, 1987. The intention of this executive order is to supplant Book 1 of the Civil Code of the Philippines concerning persons and family relations. We will discuss first Title 5 of the book, The Family. Title 5 of the Family Code, specifically Articles 149 up to 162, defines what the family is, what family relations include, and the procedures regarding the family home. Now, let's define what family is. Each of us might have our own definition of a family. Others might say it is not of blood, but of course of relationships. Others might say family is composed of father, mothers, and children. However, the law also defines family in its own nature. The law defines it as being the foundation of the nation, a basic social institution which public policy cherishes and protects. As a consequence, family relations are governed by law, and no custom, practice, or agreement destructive of the family shall be recognized or given effect. This definition of the family can be found in Article 149 of the Family Code. By this provision, it can be argued the reason why divorce is not allowed in the country is because the state provides the policy that the family should be cherished and protected, and that no law nor custom or practice or agreement can be recognized or given effect that is destructive of the family. Now let's identify family relations. This includes, first, relationships between husband and of the wife. Second, relationship between parents and children. And the third is those among brothers and sisters, whether of full or half blood. Okay, class, so please be reminded of those three existing relationships in the family relations. Now, question: if there are lawsuits between members of the same family, like quarrels among brothers and sisters regarding their inheritance, what is the requirement, if any, of the family code? To answer that, Article 151 states that no suit between members of the same family shall prosper unless it should appear from the verified complaint or petition that earnest efforts toward compromise have been made, but the same have failed. It is shown that no such efforts were in fact made. The same case must be dismissed. So class, please be reminded also that should there will be complaint or petition, it should be verified and an earnest efforts towards compromise have been made. However, that failed. Now, in cases where there is no such efforts which are being made, then the case must be dismissed. Now, the next question is, who constituted the family home? The family home is constituted jointly by the husband and the wife or by an unmarried head of a family. Is the dwelling house where they and their family reside, along with the land on which it is situated. So, class, your family home is your dwelling house, where your specific family reside, including, of course, the land where your house is situated. That is the provision under Article 152, Chapter 2 of the Code. My next question is, when can you consider that the family home is deemed constituted? So in answer to that, Article 152 of the Family Code provides that the family home is deemed constituted on a house and lot from the time it is occupied as a family residence. So remember, class, that on the time it is occupied as a family residence, then the family home is deemed constituted. Now, in addition, from the time of its constitution and so long as any of its beneficiaries actually resides therein, the family home continues to be such and is exempt from execution, forced sale, or attachment except as hereinafter provided and to the extent of the value allowed by the law. So remember, class, that a family home is generally exempt from execution provided that it was duly constituted as such. Now, who are the beneficiaries of a family home? The law provides that the beneficiaries of a family home are the husband and wife or an unmarried person who is the head of a family. Aside from them, their parents, ascendants, descendants, brothers and sisters, whether the relationship be legitimate or illegitimate, who are living in the family home and who depend upon the head of the family for legal support, are also beneficiaries of a family home. So, as stated in Article 154, the beneficiaries is important because their actual occupancy of a home may constitute the same as a family home, provided their actual occupancy of the house and lot is with the consent of the husband and wife who own the house and lot for the unmarried person who is the head of the family and likewise own the house and lot. Now, when the family home shall be exempted from execution, for sale, or attachment. That is, first, if for non-payment of taxes. Second, for debts incurred prior to the constitution of the family home. And for debts secured by mortgages on the premises before or after such constitution. So in those cases, then, the family home shall not be exempted. Such as, if those who constitute beneficiaries of the family home failed to pay the taxes or have incurred some debts or the debts is being secured by mortgages using the family home. And for debts due to laborers, mechanics, architects, builders, material men, and others who have rendered service or furnished material for the construction of the building. So in those four cases mentioned earlier, then the family home shall not be exempted from execution, from for sale or attachment in order to settle those instances. Now, how much is the value of the family home? Article 157 of the Family Code states that the actual value of the family home shall not exceed, at the time of its constitution, the amount of 300,000 pesos in urban areas and 200,000 pesos in rural areas, or such amounts as may hereafter be fixed by law. So class, if you are planning to constitute your own family home, then you are now aware of to how much are you going to prepare to save for you to start your family home. Since we are living in our rural areas, then maybe you can have as much as 200,000 pesos to constitute your family home. Then our next topic is titled 6, Paternity and Fellation. But first, we have defined paternity and fellation. Paternity has been defined as the civil status of a father in relation to the child, and fellation is defined as the relationship or the tie which exists between parents and their children. So, Articles 163 up to 174 of the Family Code deal with the issues of paternity, fellation, and legitimate children. My question is, what are the kinds of fellation of children? First is parentage according to law, their origin, our ancestral relation, and the fact of being the child of. So Article 163 provides the fellation of children which may be by nature or by adoption. Natural fellations may be legitimate or illegitimate. The Supreme Court has ruled that fellation is an important subject in family relations, such that the status of children can never be compromised. So, the Supreme Court has given effect to the policy of the Civil Code and the Family Code to liberalize the rule on the investigation of the paternity of illegitimate children without prejudice to the right of the alleged parent to resist the claimed status with his own defense, including evidence now obtainable through the facilities of modern medicine and technology. At the same time, the new Civil Code provides for two classes of children, namely the legitimate and illegitimate. So class, be reminded that the fellation of these children is fixed by law and not by the will of the parties, nor the declaration of any physician or midwife. As I said earlier, fellation may be distinguished by nature or by adoption, and by the status of the marriage of the parents. Natural children are considered legitimate if they were conceived on or before and born during the valid marriage of their parents, while illegitimate children are those conceived and born outside a valid marriage or inside a void marriage. And legitimated children, on the other hand, are those born illegitimate to parents who had no legal impediments to marry each other and subsequently contracts marriage. And remember, legitimated children enjoy the same rights as legitimate children. So now, what is the status of a child born during the marriage of its parents? Article 164 provides that children conceived or born during the marriage of the parents are legitimate. Now you might ask, what about children conceived by artificial insemination? So, Article 164 continues, children conceived as a result of artificial insemination of the wife with the sperm of the husband or that of a donor or both are likewise legitimate children of the husband and his wife. So be aware, class, that even if there was a donor for sperm, then the child is a legitimate child of the husband and the wife. Provided, however, that both of them authorized or ratified such insemination in a written instrument executed and signed by them before the birth of the child. So please take note of the last provision of the law, that there should be a written instrument that gave permission or authorization for the artificial insemination, and such instrument is being executed and signed by the parties before the birth of the child. Now, how about the instrument? Who will take care of the instrument? The law provides that the instrument shall be recorded in the civil registry together with the birth certificate of the child. So it's very clear, class, that the instrument which is being signed by both parties should be recorded or registered in the civil registry. That is to avoid claims or issues after the birth of the child. Now, next is, who are illegitimate children? Article 165 of the Code states that children conceived and born outside a valid marriage are illegitimate unless otherwise provided in the Family Code. Now, can the legitimacy of a child be questioned or impugned? Okay, there was also a provision of the law regarding that. Article 166 states that legitimacy of a child may be impugned or questioned only on the following grounds. 1. That it was physically impossible for the husband to have sexual intercourse with his wife within the first 120 days of the 300 days which immediately preceded the birth of the child because of 1. The physical incapacity of the husband to have sexual intercourse with his wife. When we say physical incapacity, that is the inability of a spouse to engage in sexual intercourse with the other spouse. Then another is the fact that the husband and the wife were living separately in such a way that sexual intercourse was not possible. This is especially if one is living so far or in a foreign land or in another place where seeing with each other is impossible. Then number 3 is in case of serious illness of the husband which absolutely prevented sexual intercourse. So these 3 instances, class, provides for the impossibility for the husband to have sexual intercourse with his wife. Then another manner by which the legitimacy of a child can be questioned is that it is proved that for biological or other scientific reasons, the child could not have been that of the husband except in the instance provided in the second paragraph of Article 164 of the Code, such as if medically it was proved that the father is not biologically not the father of the child. I mean, if scientifically or medically it was proved that the husband is not the biological father of the child. Then number 3, that in the case of children conceived through artificial insemination, the written authorization or ratification of either parent was obtained through mistake, fraud, violence, intimidation, or undue influence. So in this case, class, the donor of the sperm should have consented this activity in that his authorization or ratification of the instrument was obtained voluntarily. Also with that of the husband and the wife, that said artificial insemination was being consented by both of them, and that no one was being threatened or intimidated or being used with undue influence just to give authorization or just to ratify the instrument. Now, my question, class, is, what if the mother states that her child is in fact illegitimate? What if the mother was sentenced by a court as being an adulteress? In this case, class, the law provides under Article 167 that the child is considered legitimate, although the mother may have declared against its legitimacy or may have been sentenced as an adulteress. Now, my next question is, what rules govern when the marriage is terminated and the mother marries within 300 days after the former marriage is terminated? For that question, the Code has provided an answer. It can be found under Articles 168 that said, if the marriage is terminated and the mother contracted another marriage within 300 days after such termination of the former marriage, these rules govern in the absence of the proof to the contrary. So these are the rules that govern this issue. That a child born before 180 days after the solemnization of the subsequent marriage is considered to have been conceived during the former marriage, provided it be born within 300 days after the termination of the former marriage. Okay, class, so that would be all for the first part of our discussion of the family code. The second part will be discussed on the next meeting. And for your activity, discuss a family issue that you are aware of. Explain how the parties settled the issue. What can you suggest to the parties involved? So this is your second activity, and this will be you will be given 1 week to prepare and submit this activity in the Google Classroom. Again, thank you for watching. See you in the next video.